Hey everyone, I'm Diana Davison, an advocate for the falsely accused and wrongfully convicted. On April 12th this week, the Globe and Mail published an article by Sean Fine, who I find to be a fair and accurate reporter overall, headlined, "Top Ontario Court Criticized for Confusing Complainant with Accused in Sexual Assault Case." This is connected to an historic sexual assault accusation, where the conviction was recently overturned on appeal. One of the first things I want to mention is that the panel of 3 judges signed off on the decision as the court, instead of having one judge write the decision. Sean Fine pondered that in the article, noting it as slightly odd. I don't find it odd at all, given that this article would have been called Justice Nincompoop Criticized for Using Rape Myths if one of them had authored it alone. If you wonder whether or not judges are afraid to make proper neutral decisions according to the rule of law in a sexual assault case, well, I suggest we've gotten there. As criticism from defense lawyers points out, the article solely offered the opinions of people with an agenda, mainly anyone who's worked with LEAF, the Women's Legal Education and Action Fund, in this case Karen Siegel, and Elaine Craig, who was one of the academics who helped oust former Judge Robin Camp by, I'd wager, intentionally misrepresenting everything he said in court. I guess Miss Craig to have intentionally misdirected the public because I have great respect for her understanding of the law and of legal proceedings. And yet, as Brenda Kosman pointed out far too late, everything was indeed taken out of context by Elaine Craig and her colleagues. Ms. Kosman only told the truth because she was pissed off that Camp got booted after she indoctrinated him with her highly suspicious re-education program. Link to a video about Robin Camp below. This whole article turns out to be an attack against the legal system for making typos in their verdict. The complainant was mistakenly called the appellant twice, and we're wrongly told that's because judges see victims of sexual assault as if they are the accused person. First of all, for my US audience, buckle your seatbelts. In Canada, people can be retried after acquittal. That's right, we don't have double jeopardy law here. So someone can be acquitted and then have to pay for a lawyer on appeal, and then maybe pay for a retrial, and then maybe pay for another appeal. It can pretty much just keep going on and on. Second, judges who acquit someone of sexual assault now worry about being attacked by these people with an agenda in the media. Robin Camp was an object lesson on how feminist lawyers can and will destroy you if you reach the wrong verdict. Third, acquittals are being overturned because of a sentence or a paragraph that a feminist can pounce on as a rape myth. But the Crown, that's our state, will use completely opposite arguments when you try to overturn a conviction. I'll give you an example from an appeal case I'm attending in Calgary on May 8th. The Calgary man was acquitted of sexual assault for a variety of reasons, not least of which was that the accusations came in the midst of a custody dispute with his ex. Additionally, his ex was found to have instructed the kids to lie to police in a previous altercation, and when the oldest girl made a second police statement, she said she was worried that without her second statement it would hinder what they wanted to accomplish. Counsel did not pursue this comment. Who was they? What exactly did they want to accomplish? Was that more important than the truth? And finally, the girl's memories were not found to be reliable. The appeal court, under pressure during the time of the Robin Camp fiasco, sent it back to retrial on the grounds that the judge may have employed rape myths by holding children's memories to too high a standard, and perhaps he was overly concerned with how long it took for the girls to disclose the abuse. Now, I've seen many denials of conviction appeals where the court finds that an error of law seemed to have taken place, but if you remove that error, there were other sufficient grounds remaining. Put simply, yeah, okay, that part was wrong, but take it out and the verdict remains the same. In appeals of acquittals of sexual assault trials, it doesn't matter if that one comment could be removed and the acquittal still stands. The fact that the mother had coerced the kids to lie to police in the past, that the eldest said to police there was something they wanted to accomplish with the complaints, and that it was in the middle of an acrimonious custody battle, well, we can completely ignore the rest of the decision. Here's something that annoys me the most, though. On the appeal of his wrongful conviction, coming up on May 8th, the Crown, the state, is arguing this. The Supreme Court has repeatedly recognized that it is difficult, if not impossible, to articulate with precision the various factors influencing the ultimate judgment about a witness's credibility. The assessment of credibility is not a science. It is a difficult and delicate matter that will not always lend itself to precise and complete verbalization. So, you see, and I agree with this, a judge can't be expected to word their ideas in precise alliance with the political correctness of the day. They can't be expected to avoid typos. They also can't be scrutinized differently depending on whether or not the case they tried was about sexual assault. To see the Crown making an argument that would have blocked their appeal of the acquittal just infuriates me. This is not a game of words. These are real people. The man in Calgary is an innocent man who's spent over a year in prison on a wrongful conviction. This is not about words. If judges are going to make decisions based on media and public pressure now, because they aren't being protected from rabid ideologues with an agenda, I want them to see me in court so judges know that I'm watching too. And if you live in or near Calgary and want to help make sure an injustice doesn't stand, let me know. My contact info is in the description.